Hey you guys, and welcome back to Taking Flight with me, Mike Rocket Blackstone. Now some of you may know that I also have a business called Air Combat USA that was based in Fullerton, California at the Fullerton Municipal Airport for over 30 years. In 2016, the airport manager Brendan O'Reilly breached our 30-year lease and wrongfully evicted us in 2017. We've been struggling for survival since 2017, locked in a battle with the City of Fullerton, seemingly to the death. We won our court case in 2020 with a unanimous verdict in COVID. The city didn't like that outcome and they took us to the appellate level, which we just had our oral arguments, which is the final step of the appellate process in the state of California. I've posted the actual hearing from yesterday, so you can take a look at it. It's about an hour long. Bear with us, it is long. The City of Fullerton's attorney versus our attorney, Todd Lundell of Sheppard Mullin, did the best job they could yesterday. Our survival is now in the hands of these three justices. Please pray for the survival of Air Combat USA.
Air Combat versus City of Fullerton. Appellant may proceed. Let me just stop you for a minute before you argue, counsel. There's an appeal and a cross appeal. We have 30-minute estimates from both sides. So usually we defer to you, and if you want to make sort of your argument in its entirety, you can. Or once we get through the appeal and the response, then the cross appellant can use some of that 30 minutes to argue the cross appeal. I really generally just leave it up to you, but I want you to know we are aware, we've read all the papers, and we know there's an appeal and a cross appeal, and you both have 30 minutes to use it however you'd like.
Okay.
Okay? And I will.
Do we have to agree?
You don't necessarily have to
Okay.
agree. I will monitor it, and I'll ask you probably, if it's not clear to us what's up, I'll probably come back and revisit this in about a half an hour and say, okay, have you argued the cross appeal yet? Have you responded to the cross appeal? But I will keep time. We have a timer up here, as I'm sure you know, and we have about an hour to spend on all aspects of this case. Okay?
Okay.
Go ahead.
Thank you, Your Honor. Krista McNamara-Jee for the City of Fullerton. May it please the court. There's a number of issues that the city brought on appeal. I would probably just prefer to go ahead and address all the issues that, and in response to the cross appeal. One of the first just sort of preliminary issues is the standard of review on the primary issue that the city is bringing, which is on the contract interpretation. And we had asserted clearly that the standard of review is independent judgment. And I know Air Combat had made some assertions about that not being the case. There are a number of facts, and obviously the contract requires some going outside of the terms of the contract, but any of that extrinsic evidence was largely undisputed. There were not really any factual disputes. Really, what the court was referring to in its statement of decision was divergent inferences that the parties were making in applying those facts. So I think it still has an independent judgment standard of review. There really wasn't much of a credibility determination. I think there might have been some. Clearly, the statement of decision ignored a lot of facts and found them sort of confusing and not helpful. But that still circles back to the standard of review for this court being independent judgment, and that's pretty key, of course. And of course, for the first primary issue for the city is the contract, the lease interpretation itself, which
The city wrote the lease, Ms. G, right?
well, okay. So what the trial court focused on was the fact that it was on city paper, was the way the court referred to it. It has the city's seal on it. The city manager signed it.
I know,
All the other,
causes one to reasonably infer the city might have drafted it, don't you think?
yes, but there was clear testimony from one of the only people who was present at the time of the lease signing, the then airport manager, who clearly testified that there was back and forth, and specifically as to one of the primary terms at issue here.
Maybe a better way to characterize it would be that the city generated the final form of the lease.
Maybe printing it out for purposes of signing, but I don't think it's fair to say that for purposes of drafting.
Would you characterize the lease as a model of clarity with respect to
No.
when the lease began and terminated?
No, absolutely not. Some of that may have been precisely because of this back and forth that went on. So the wording of the lease got modified through that process. Like the airport manager testified that it was about the year before that the parties were going back and forth about the terms of the agreement.
The city was apparently satisfied with the final form in that it did print it out on city stationery.
Well, it gets recorded, it's a city lease, it's for the airport. I don't know what requirements there are for the FAA for the airport property or whatever. Yes, I mean, obviously it has the city seal on it. That's
You're
what
not trying to run away from the language of the lease, are you?
No. And in fact, I think the court can narrow it down much more closely to not only the terms actually stated in the lease, but also the conduct of the parties around the time of the signing of the lease and immediately thereafter, before any dispute arose. And that's what before the court even gets to the point of who drafted it, the court is supposed to go through all of the hierarchy of contract interpretation. One of the last ones is who drafted it. If nothing else leads you to a conclusion, then you can look at who drafted it. But there's a lot of other tools that the court can use before that. The primary one is the language of the lease itself. So granted, the court has to go to some extrinsic evidence because there's this OCFA vacated. When did OCFA vacate? So we have to go outside to determine that. But what
there's evidence about that, right, that the judge heard?
Yes, it's
When
undisputed.
the crane came and when they moved the various things and
Yes, but the court came to that conclusion based on when did OCFA vacate? And the court specifically concluded vacate does not mean moving out. And that is legally unreasonable. I think the common sense understanding of vacating is moving out. It's precisely moving out. It's the new
By
tenant
moving out, you're talking about moving every single thing you ever had on the premises?
No.
So
No.
what's the difference between vacating and moving out in your mind?
Well, the vacating is that the current tenant is out of the premises, the new tenant comes in and can occupy it, make use of it, and normally start paying rent. Of course, there was delayed rent in this instance. But the primary problem, one of the first primary problems that the trial court did was it made this unreasonable determination of what vacate doesn't mean move out. And that's not, I don't think, reasonable.
What do you think Judge Crandall determined was the pivotal date or the pivotal moment?
Oh, he relied exclusively on the helicopter being removed.
And are you contending that was wrong?
Yes.
Why?
Well, the primary reason is because he first concluded that vacate does not move out. So
We heard you.
Yeah, so he immediately excluded the fact that OCFA turned in the keys, left end of February, beginning of March, and Air Combat was in the beginning of March. So he eliminated that. And then the other thing that was unreasonable about that is that it treated that piece of property that was left behind, granted, there was left behind property. So then the question is, what does the court do with that? There was left behind helicopter, there was left behind blue cage. And the court did not treat those two pieces of similar large equipment the same. It used the removal of one as triggering the vacate date, but not the removal of the other one. And under the court's reasoning, the remaining blue cage means that it never commenced because there was a piece of equipment that had been left behind by OCFA that wasn't removed.
But the court gave you the date of October 1st, right? And that didn't say never.
No, but based on the court's own reasoning, that is the logical conclusion, is that the helicopter remained and the blue cage remained, and there's no legal basis for distinguishing between the two.
He felt there was, though. I mean, he discussed that. He thought they were different.
No, what he referred to was the fact that the blue cage he disregarded. He found that there was an agreement, but he found that that couldn't modify the terms. But the problem is that he also didn't take into account. So there's other evidence that is more directly related to the terms of the contract and the conduct of the parties.
Well, that's a matter of weighing and of examining, evaluating, and weighing the evidence, isn't it? You say some other piece of evidence is more significant, but that's really up to the trier of fact, isn't it?
No, because first of all, it's independent judgment by this court, and it's a contract interpretation, and it's
If it is
going.
independent judgment, if we disagree with you,
Right.
or excuse me, if we agree with you, you still have to convince us that, I mean, we're always going to look at the trial court's evaluation as we do our independent review.
Right.
And maybe it's unspoken, but you got to convince us that he was wrong if he evaluated it in a different way.
Right.
Maybe that's not the legal analysis, but that's the reality.
Right. Well, going in the order of what the court is supposed to look at for purposes of a contract review, there's other pieces of evidence that are more directly related to the actual language of the contract and the conduct of the parties. So, and these again are not matters that are really factually disputed. They're undisputed.
When you're talking about the conduct of the parties, I was going to ask you this later, but it's on my mind right now, so I want to ask you so I don't forget. What significance should we attach to the alleged statements made by the manager about when the lease was going to expire? I think in June he said it was October, and then I think
Right.
before that he had said October, and then suddenly a week or two later in June he said, oops, your option expired already.
Right.
What significance should we attach to that?
Well, none. I mean, the court disregarded that, finding that it was confusing and not helpful, and that was
You're asking us to do an independent review, so
right.
you can't have it both ways. I think that may be significant, so you might want to address that.
Yes. I mean, the fundamental problem with the October date is that it primarily came from the then airport manager, the later airport manager, O'Reilly,
Right.
had come into the job new. He had asked a secretary or some assistant to prepare a chart
Spreadsheet.
right. What they called the cheat sheet during trial. It was all of the leases that were at the airport, and literally the assistant went by the date of the agreement, June 1st, counted 3 months, and got October.
So you're just saying he was wrong, and so we should just disregard the fact that he told Air Combat that it wasn't going to expire until October. It's a little unfair to Air Combat, perhaps, that your manager is telling him that it doesn't expire until October. Why couldn't they rely on that?
Well, I mean, there wasn't really an argument in terms of reliance on that, but the problem with it is that, so what I was going to get into was some of this other evidence that was there. The trial court concluded that that was a confusing date and that the parties didn't know what the date was, and they were asking questions. The airport manager was asking that question. Air Combat, I think, didn't even have a copy of the lease, so they didn't know, but I think all of the parties are equally charged with knowing that. The trouble was that the two parties that were communicating at that point in time weren't there when the lease was originally entered. So the airport manager at that time wasn't the airport manager that signed it. The president of Air Combat, or the trying to be president, I think he was in the process of working that out at the time, wasn't present during. I mean, I guess he signed it, but he wasn't part of the negotiations because his father was the one that was in charge of Air Combat. Right. So,
Ms. G, good morning. The confusion that Justice Goethals has raised and that you're discussing is added to or exacerbated by the fact that the city attorneys also felt that October 1st was the date. Was that based on the cheat sheet as well? What was that? And the verified answers, as I understand from
well, the answer wasn't verified, Your Honor.
Okay.
The statement of decision refers to it as a verified answer, but it isn't actually verified.
All right.
It isn't required to be verified by the city. And at that point in time, everybody was operating off of the sort of assumption that it was October 1st, probably stemming from the cheat sheet. When the airport manager asked that question of the city attorney, she said back to him, where is October 1st coming from? So, and that question was never answered. So the question was presented to her sort of more like, assuming October 1st, 2011 was the date that the lease started, when does the 5 years expire? And so that was the question she was answering. And her email included the question of, where is that October 1st date coming from? So it wasn't like she made that legal determination at that point in time. And so, but
I'm sorry, who asked the question? Who was this colloquy between?
The airport manager was asking the question of the city attorney.
Okay, but Air Combat was not privy to that communication.
I think the communication eventually was forwarded by the airport manager to the secretary, or I'm not sure what her position was, or an assistant or someone with Air Combat.
And you're saying the question was never answered?
Not by the city attorney. The city attorney, when you read the communication, it's very clear that there's certain assumptions that are there, and it's not that she was making like a legal determination at that point.
Verified or not, it was in the answer.
Yes.
It got to that point.
Yes.
Thank you.
And the city had acknowledged that it was a mistake, and I think that the trial court recognized that and realized that everyone was confused and was kind of trying to narrow it down to, what's the heart of the legal determination. And so we come back again to the problem of the fact that the court, misdefined, if you will, the term vacate. It treated the helicopter removal differently than the blue cage, and they were equal kind of pieces of left behind equipment.
Well, I'm glad you brought that back up, and I'm sorry again we're all peppering you with questions, but I understood from the record that there was some kind of side deal between Air Combat and the fire authority.
Yes.
That the blue cage would be left on. Isn't
Right.
that a distinguishing factor that would justify treating those two items differently?
Right. Well, except the agreement was that the one was in exchange for the other. So if the court's decision sort of disregarded that. So it said that it found that there was a side deal, but that it couldn't change. It still had to come back and determine when Air Combat had or OCFA had vacated. So but the way that it treated that was not consistent between the two pieces because it completely disregarded that agreement. If it had taken into account that agreement, then it would explain why there was that situation, and it still supports the fact that the time when OCFA moved out is really the time that determines the vacating of OCFA. And then there was, as I was indicating, other strong evidence from the contract itself that supports that. So the initial term or the rent on page 9 of Exhibit 1, which is the lease, the rent starts on the commencement date. That was also the changed rent was sent by invoice to Air Combat in June, and it was first paid in July. That's an undisputed fact. Now, the parties had differing inferences, again, as to those, but those facts are not disputed.
Why is that so significant in your mind that the rent actually was first paid in July?
Well, because on page 9 it says the rent starts on the commencement date. So the commencement date.
It was actually paid in June, and then it was kind of confusing exactly what happened.
Right.
It was due in June, but they didn't pay until July. Or somebody thought it was due in June.
The invoice was dated in June, I think June 26th or 27th, and it was due on July 26th. They paid it on July 22nd. The dates don't exactly line up, but in terms of the payment of it, that's when the new rent was taking effect, was June, and was paid in July. And then more importantly...
So you think that's an acknowledgement by Air Combat that the rent was due as triggered by the lease?
Well, it's the conduct of all the parties. So the city is sending them the new rent in June, and Air Combat is paying it. And I understand they have different viewpoints of that, and there was different testimony about that, but those bare facts are there. What
They've
supports
still been
it,
told in June, though, by the airport manager, same month, June, I think, and again, you know the facts better than we do, but they had been told by the airport manager in June that the lease wasn't going to expire, or the option wasn't going to expire until October, right?
yes,
All these things are happening kind of at about the same time,
yes, I mean, that was years later, when the 5 years is going to expire.
right?
But the other important point is in that same, on page 9, is the CPI increase happens every year on the anniversary date of the commencement date, or the anniversary of the commencement date. So again, it's using the commencement date in all these places, and that is consistent with the conduct of the parties. So the parties acted like July 1st was the anniversary date, and the rent was paid in July, and so all of that is consistent with Air Combat or OCFA vacating in February, March, and Air Combat coming in March.
Just so you know, you've used about 18 minutes of
Yeah.
your 30. And so I told you I'd remind you, I'd like to make sure that we, depending on how this all plays out, that you have enough time
Yes.
to respond to their cross-appeal arguments.
Right, and I appreciate that. I mean, I know that this is the trickiest issue, fact-wise. So I know it requires some use of time. I don't know if there's any other questions. I mean, there's a lot of facts that relate to it. I think it kind of comes down to, though, in terms of the contract interpretation, I think those are the primary issues that the court should and can use at the beginning of a contract interpretation. There's a lot of other facts that support the same timeline. So, like Air Combat beginning operations, there's photographs establishing that in June. They actually were done with the build-out. They were actually operating, they were conducting business. There was the argument, and in the statement of decision, there was reference to the inability to use parcel B somehow because of the helicopter. That's similar to the inability to use the area where the blue cage was. But also, Air Combat always was using that area for storage, and that's also established by the photographic evidence. And the Air Combat was in and had dominion and control and use and exclusive occupancy of all of the area, except for the helicopter and the blue cage, of course. The other primary issues that the city had raised was the failure of the claim to match Air Combat's complaint, essentially. The primary focus of the claim was on the RFP process, and it didn't touch on anything relating to the claims that were the primary crux of the entirety of their case, which was the claim of misrepresentation and an alleged interference of the city to allow them to renew the contract. So this defeats the validity of their claim. And it has a lot of underlying problems with that contract claim because of the government immunity for misrepresentation, and the fact that the anticipatory repudiation claim that Air Combat finally got it down to after the third amended complaint isn't proper when we're discussing an option.
You're now at about 20 minutes, just so you know.
Thank you. The other issues related to the tax returns, which were a unique piece of evidence that the city should have been allowed to introduce, different than Air Combat's QuickBooks data, even though the court had concluded that they were the same. They weren't the same in the sense that the Michael Blackstone Sr. had signed them under penalty of perjury. Obviously, he wasn't around to testify at the time of trial. So the tax returns gave some strength and validity to some of the costs that were in there for Air Combat, apart from just what was in the QuickBooks. The other two remaining issues that were of the city's were the court's taking away of the punitive damages issue. There was sufficient evidence for that to go to the jury. The court applied the wrong standard in terms of what needed to be shown about some kind of intentional act to harm, and really it's an intent to annoy or injure or callous disregard for the rights of the owner. And that all was established by the evidence in terms of the things that Air Combat removed. Not that it was sufficiently established just there, but the fact that it should have gone to the jury. And the final issue for the city was the attorney's fees. And the court directly acknowledged the attorney's fees, especially as to Attorney Chow, were totally unbelievable, offensive, completely overdone. So the court already made the findings. We recognize that that is subject to abuse of discretion, but having made those findings, it didn't then go the next step to sufficiently reduce or eliminate the attorney's fees. The final issue that is Air Combat's issue is the specific performance. And that also has a standard, abuse of discretion standard. But this court can uphold it on any basis. Essentially, it boils down to the fact that Air Combat took this to the jury on damages, and the specific performance issue wasn't brought up until later, after the verdict, when the judgment, even after trial was over, and when the judgment was going to be entered. It was just too late to have, it had already made its election of remedies. The jury had already made a determination of damages. And the bigger problem that the court had at that point was that the property had already been leased. So to require such an equitable remedy to overturn an existing lease just violates the general basic principles of equity. And if I have any time left, I will reserve that.
Counsel, you got 7 minutes left.
Thank you so much, Your Honor.
Use that to reply and also to comment on arguments with respect to the cross complaint. Mr. Lundell?
Thank you, Your Honor. Todd Lundell on behalf of the respondent and cross appellant, Air Combat. I appreciate you keeping the time. I do want to make sure I get to the specific performance issue, but I also want to answer any questions the court has.
You can use all your time, your whole 30 minutes, however you want. If you want to use it all in this single argument, you can, or you can reserve some to respond to any argument made by Ms. G with respect to the cross complaint.
I may reserve 3 minutes. Let's see how.
Okay, we'll see how it goes.
So on the primary interpretation of the lease question, the first issue is the standard of review, and the city does face a quite daunting standard of review here. Whereas here the lease is ambiguous and the extrinsic evidence regarding the lease's meaning is in conflict, this court will uphold any reasonable construction of the lease that is supported by substantial evidence.
Mr. Lundell, good morning.
Good morning.
Ms. G talked about how much of that evidence was not in conflict. Would you address that as you continue your answer?
Sure. I mean, the trial court who sat through trial said this about it. The parties presented sharply divergent versions of many of the key events and facts. This court's findings and conclusions thus necessarily reflect its evaluation and determination of the credibility of each of the witnesses who testified. The trial court certainly saw lots of disputed facts that bore on the question of the lease, and made didn't make the credibility determinations, but said that its decision was based on credibility determinations. In that context, the standard of review here is the one that I said, which is any reasonable construction should be upheld that is supported by substantial evidence. And the truth is, and by the way, the city did draft the lease. The court specifically found that the city was the drafter of the lease. Mike Blackstone Sr., he's not an attorney. Sure, he may have had some discussions and negotiations about what the lease should provide, but that doesn't change the fact that the city itself was the drafter of the lease. So they also face the hurdle of any uncertainty in this lease is construed against the city. But I actually think that at the end of the day, the analysis can be pretty straightforward, and it's this. We know that the effective date of the lease is June 1st, 2011, right? And the lease explicitly recognizes that as of that date, the OCFA is still the, quote, current tenant. That's what the lease says. And that the OCFA must do something in the future to, quote, vacate the premises. And that's going to trigger the commencement date. So what must it still do to vacate as of June 1st, 2011? Well, we know that although Air Combat had been given some access to the property. And they had not completed renovations, by the way. That's just, there was conflicting evidence about that. And inferences are in the judgment's favor. They did not throw their grand opening party until September. They were conducting some business out of the property in late June, and they were given some access in March, but they had not completed all the renovations. But in any event, so they've been given some access to make improvements, but the OCFA had still left behind the huge helicopter and blue cage, valuable property that it intended to come back and remove. Given that context, it's clear that the future event that would trigger the commencement date is the date the OCFA returns to remove its property. That date's July 1st, 2011, right? So the trial court's finding that October 1st, 2011 is the commencement date, the 3 months later, is supported by the plain language of the lease and the context in which that lease was signed, right? And to Justice Goethel's point, the city did repeatedly state to Air Combat, to the public, other places, that the lease expired in October 2016, 5 years later, right? So in March 2016, the city attorney tells O'Reilly that the expiration date is October 1st. O'Reilly sends that to an Air Combat employee and says, it doesn't expire until October 1st, 2016. O'Reilly's own spreadsheet shows that. The city attorney stated that date in the letter they used to evict Air Combat. And then the city issues a press release to the public that says the expiration date is October 1st, 2016. And there is, of course, an issue of reliance. Mr. Blackstone testified at trial that he repeatedly met in person with Mr. O'Reilly and said, I'm here to exercise the 30-year option. And Mr. O'Reilly says, plenty of time to do that. It's March, lease doesn't expire for a long time, plenty of time to do that. Until finally in June, he pulls the rug out after reassuring Mr. Blackstone several times. In June 2016, he pulls the rug out from Mr. Blackstone and says, oh, too late. When in fact it wasn't too late. Air Combat had until 60 days before the October 1st date to exercise the lease option. So it wasn't too late. So the city clearly repudiated and said, we're not going to honor the 30-year option, it's too late, when in fact it was not. So the city's basically put in the position of arguing that the trial court's interpretation of this lease is completely unreasonable, even though it's the interpretation they gave the lease for both before and after this litigation began. They did state in their answer repeatedly that the expiration date was October 1st. They even stated that Mr. O'Reilly knew that the expiration date was October 1st. And then Air Combat moved for a TRO, and Mr. O'Reilly puts in a declaration under oath that says, I knew the expiration date was October 1st, 2016, even though he had told Air Combat before that it was expired earlier. So their proposition, they really have two arguments here remaining, and that is this blue cage argument that there's no distinction between the two. But the distinction between the two is that the OCFA made a distinction between the two, right? They came back to remove their property. They got the permits, removed the huge helicopter, multi-ton helicopter that off the property, and then they said, we'll leave the blue cage. We abandon the blue cage, or we give it to Air Combat, whatever it is. But at that point, there's nothing left that they're going to come back for. So at that point, it's reasonable, certainly reasonable for the trial court to say, that's the vacature date, right? That's the date that the OCFA said, there's nothing more we're going to have to do with this property. Before that, they were coming back. After that, we're not coming back. We don't have any rights to this property anymore, right? That's certainly reasonable. The only other evidence they point to is the rent payments that they started in July of 2011. And the problem with that is it's very clear that the parties did not pay particular attention to the strictures of the lease when it came to the rent payments. The lease says rent has to be paid at the beginning of the month for the month going forward. Air Combat was billed. The city's bills stated that it would be due at the end of the month. The Air Combat paid at the end of the month because it just paid the bills as it came in, right? They never applied any penalties for it, even though the city says we don't excuse late payments. So they're not following the lease when it comes to rent. And the trial court also noted that Air Combat had been, of course, at Fullerton Airport for a long time, and it was moving to a new hangar that was cheaper. So when it receives an invoice from the city that is for the lower amount, of course it's going to pay that lower amount. But that doesn't change the effective date or the commencement date in the lease. They're going to continue to pay whatever is invoiced by the parties. Michael Blackstone testified that his father just paid the invoices as they came in. But the city can't unilaterally change the commencement date by sending invoices that way. So I think that covers the lease provisions. And so I want to turn to, excuse me, Your Honors. Unless the court has any questions about that, I'm happy to answer them.
We'll ask you if we have questions.
I'm aware. So on the Government Claims Act section, they say that the claim that was tried to the jury was completely different from the notice of claim that was given to the city, and that's just simply not true. While it's true the notice of claim talks about the RFP process being unfair, the notice of claim states specifically up front that this was a breach of the lease, that putting the lease out for RFP to allow a new tenant to come on was a breach of the lease because Air Combat had exercised its option. Now, courts have consistently stated that a plaintiff's notice of claim has to be interpreted in light of the purpose of the statute, and that is to give the government entity notice sufficient to allow it to investigate the claim. Okay? And it's not to, be applied in a way to snare the unwary. If there's enough information in there to investigate the claim, then it's sufficient. And while it's true, the claim doesn't use the words anticipatory repudiation, it's not required to. It says that we exercised the lease or the option, and the city put it out for RFP anyway, and that was a breach of the lease. So if the city was going to investigate, what would they do? They would go to Mr. O'Reilly and say, did Air Combat exercise the lease or exercise the option? And he would say, no, I met with them multiple times, and eventually I told them that it was too late to exercise the option. That's the very heart of this case, right? That is, if they do the investigation, the question is, do those circumstances that would inevitably be investigated amount to a breach of the lease? And the answer, as the jury ultimately found, was yes, that those circumstances were. So this notice of claim very easily puts the city on sufficient notice of the breach of contract claim that was ultimately asserted by Air Combat and tried to the jury. It's very similar to the Stockett and Blair cases. In each of those cases, the notice of claim stated a cause of action based on one theory, and then the complaint asserted the same cause of action based on additional or different theories. And the courts in both cases said the new theories were proper because the claim gave sufficient information to investigate. And that's the case here. They had plenty of information to investigate. And by the way, I think it's notable that they litigated this case for 2 years. They never demurred on this ground. They never filed a motion for summary judgment on this ground. On the eve of trial, they filed a motion in limine that was a thinly disguised, not even thinly disguised, dispositive motion. And the trial court recognized, hey, that's not really proper, right? And then it went on to decide the merits that this notice gave sufficient information. And this court should affirm on either of those grounds. They had waived it by litigating this case. I mean, if the purpose of a notice of claim is to provide the city the opportunity to investigate, they had certainly investigated during the 2 years that they litigated this claim before even raising the issue to the court. So either of those grounds, I think, are sufficient for this court to affirm. The city briefly mentions the tax return issue. This is an issue that's well within the discretion of the trial court. The tax returns, again, there's an issue of waiver here. At the outset of the motion in limines, the trial court said, these are going to be my tentative decisions. If you think I'm wrong, bring it up at trial. There'll be new context at trial. Bring it up at trial. And then in regard to the motion in limine with regard to the tax returns itself, the court says, after lots of argument, the court says, that's my decision. The parties can revisit it during trial, but, quote, that's my tentative ruling. So he invited the parties to revisit it at trial, said that's his tentative decision. And yet the city never revisited it at trial. They never said, look, in the context now, please admit the tax returns. Under People versus Holloway, that's a clear waiver. In any event, the trial court had within its discretion under 352 to weigh the probative value against the prejudice and the undue consumption of time. They said, let us admit this tax returns because we're going to have an expert testify on general accepted accounting principles and government processes for tax returns. This is all at the hearing. And the trial court is basically saying, why would I send the jury down this rabbit hole of generally acceptable accounting principles when you have the underlying data? No one is disputing that the tax returns are going to reflect the underlying data. So adding the tax returns and sending the jury down this rabbit hole of irrelevant information is just going to be an undue consumption of time in a trial that was already going on quite lengthily. So I think the court was well within its discretion. And the final point I would make is they just can't show prejudice. The jury here heard lots of evidence, lots of expert testimony, they had the opportunity. This is all relates to disputed costs and loans that Air Combat made, and whether how profitable the company had been in the years prior to trial. And the city had plenty of opportunity to put on fact witnesses that would testify as to those loans and those disputed costs. Larry testified to some of them. On the loans, he deferred to their bookkeeper, Joy Larson. Joy Larson took the stand. The city didn't even ask her about the loans. So they clearly didn't really think this was much of an important issue until, comes time to appeal, and now it's a much more important issue because they want a reversal. So they can't show prejudice. It was reasonable, and they've waived it anyway. I want to make sure I do have time for specific performance. How much time do I have left?
You have about 16 minutes left.
About 16 minutes?
You've used about half your time, a little
Okay.
less.
Well, I'll address the punitive damages shortly, and then I'll move to the specific performance remedy. On the punitive damages, the city said that the court applied the wrong standard, and they just cherry-pick language from the hearing to make that claim. And the trial court at the hearing read from the case instructions and said, this is the standard you have to meet. And then said, where's the evidence that would meet that standard? And again, there's sort of a double hurdle here, right? The city had to put on clear evidence that was sufficient for the jury to find by the clear and convincing evidence standard the punitive damages were warranted. And we all know that clear and convincing evidence is the sort of evidence sufficiently strong to command the unhesitating assent of every reasonable mind, right? And then the oppression, fraud, or malice prong is equally a strong prong. You can't just show negligence or carelessness. It has to be the sort of conduct that's a reckless indifference to the plaintiff's rights. In the context of this claim, this all relates to the conversion claim that the city made against Michael Blackstone and Air Combat. When they left the property, they took down a lot of the tenant improvements that had been done. And the city made the claim at trial that it was entitled to all of those tenant improvements. And therefore, anything that he removed from the wall must have been done maliciously because he wasn't entitled to any of it. Air Combat wasn't entitled to any of it. Well, the lease actually says when Air Combat leaves, to return the property to the same condition it was in when the Air Combat entered the property. And that was in March of 2011. In March of 2011, this property was completely dilapidated. And so Air Combat looked at the lease and said, we have the right to take the tenant improvements. And so it got a crew together and said, take the tenant improvements, leave this property, gave them photos of what the property looked like in March 2011, right? The leader of the crew that did the demo, that took this down, said, I got a photo of it, I looked at it, and I, took what was not there before. And the existence of that dispute, it's not who's right in that dispute, it's the existence of that dispute shows the lack of malice, right? What the court asked at the end was, where is the clear and convincing evidence that any damage to the property was done maliciously, as opposed to Air Combat just acting because it had a different read on the lease and on who's entitled to the tenant improvements? And there really isn't any. There's certainly not that would meet the clear and convincing evidence standard.
Well, there was damage done wasn't there?
There was, but
Prior fact found that there was damage done to the tune of $10,000.
That's correct, Your Honor.
So that was all in the removal of the tenant improvements, nothing else?
That's correct. Well, so in the moving out, there was $10,000 worth of damage done. Note that they sought $110,000 because their expert only testified as to what it would take to return the property to the condition it was in when Air Combat left. And their expert said it would take $110,000 to return the property to that state, right? And Air Combat said, well, that's not the state we were required to leave it in. We're required to leave it in some other state. And the jury finds $10,000, which is clearly a rejection of the city's argument that it had to be returned to the condition that when Air Combat vacated in 2016, or 2017, I guess, because no one disputes that if you wanted to return that property to the condition it was when Air Combat left, it was going to cost much more than $10,000. So what the jury finds is that perhaps the crew in removing some of the tenant improvements and stuff had been negligent or what caused some damage. There's no question. And so there's a $10,000 award. Hardly shows punitive damages, though, right? The clear and convincing evidence that would be necessary for punitive.
Well, you can have punitive damages on a dollar.
You could.
So it's really not the amount of money of the damage. It's what can be inferred from the evidence that the damage was caused, isn't it?
It is. And I don't mean to state that the $10,000 in the abstract. I mean the $10,000 in contrast to the claims that the parties were making. In other words, it shows that the jury had...
The city wanted a remodel, perhaps, or maybe I'm overstating that, but yeah. But again, the amount of money isn't dispositive at all.
It's not, but it shows that the jury understood that there was this dispute and that the city wasn't entitled to all the tenant improvements. And that's the basis of their punitive damages claim. They basically say, we're entitled to all these tenant improvements, so taking them all down must have been malicious, right? And they do point to some evidence that it was, the things that we're taking out. There's ceiling tiles missing. There's a sink removed. I'm sure she'll refer to that in the reply. Things like that. At most, again, that shows negligence. And the trial court sat through this evidence, understood very, very well what the evidence had been presented, and made a determination that there wasn't enough to clearly and convincingly establish malice.
Was the sink there? The evidence of this, was there the sink there before?
The evidence showed that the sink was there before. So there was some things removed. Again, Michael Blackstone himself wasn't there doing the removal. He hired a crew and perhaps even negligently should have been there to supervise or whatever to make sure those things weren't removed. That didn't happen. But that, they've got to show that basically that Mr. Blackstone maliciously instructed his crew to go in there and tear everything down, leave it in an unsafe condition, and recklessly disregard the city's rights in taking it down. There's just no evidence of that, right? So I do want to turn to...
You're down to about 8 minutes.
Okay, I want to turn to specific performance. The specific performance, the trial courts denied the specific performance remedy because it said awarding specific performance would amount to a double recovery. And that's just wrong as a matter of law. The jury award here divides the damages into two parts. There's the past damages and the future damages. Past damages are obviously fully consistent with an award of specific performance because those damages are going to be suffered regardless of whether he gets the property back. So the question is, what about the future damages? As to the future damages, Air Combat had the right to elect those damages, either those damages or the specific performance, and it had until entry of judgment to do so. In other words, it was entitled to know whether it had the right to specific performance before electing between the two remedies. And that's the Ramsgate case, the Rome case, the John Jahn case specifically says, we are asked to decide if a plaintiff may be permitted to elect between equitable and legal remedies after the jury has returned a verdict. And the court says, yes, the plaintiff there could elect the rescission remedy even after the jury had returned a verdict for damages.
Although normally the election of remedies extends, as you have just described it in those cases, it is an equitable remedy. And why was Judge Crandall wrong, as I read his comments, in determining that he didn't want to apply that equitable remedy given what had happened in this case?
I don't think that's what Judge Crandall said. I think what he said is
this what he said, but I'm reading everything that Judge Crandall talks a lot. I'm sure you've noticed. And in this trial was no different. And looking at this record and some of the comments made by Judge Crandall throughout the proceedings, my impression is he thought there was either an election had already been made, even though the cases that you have cited say otherwise, or that then there had been a waiver of that remedy based on the prior conduct in this case? Why was he wrong in concluding that, considering that he was there, he saw it all, and he heard it all, and it is an equitable remedy?
It's a legal error to put a party to an election of remedies before he knows whether he has an entitlement to the remedy. I mean, that is the John case and the Ramsgate case and the Rome case. They say you have an entitlement to hear whether what remedies are available, and then you get to elect between the two. And it's just not true that you can't try damages first and then have a specific performance remedy. And I'll note, Your Honor, that in this case, of course, the case had to go to the jury before a specific performance remedy could be awarded, because the jury had to determine breach first. Specific performance is a remedy for a breach of contract. So the jury had to determine breach of contract first before a specific performance remedy could even be considered.
Did you ever raise the specter of specific performance before you submitted that judgment?
Well, the specific performance was raised in the complaint. It was raised during trial. It said, the trial court said, we'll deal with specific performance after the jury's done with its job. And it was repeatedly done.
Remind me when and how it was raised during trial,
So
that
there-
potential remedy.
There was a point at the end of trial where the court's trying to figure out what's left. And what was left at that time was inverse condemnation and specific performance. And the city made an argument that, hey, look, inverse condemnation, if there was a claim for such, the jury gets to decide damages. So, Your Honor, you have to decide the inverse condemnation claim first. As to specific performance, so the court does, by the way, the court says no inverse condemnation here. And so the jury doesn't have to decide damages for that. And then at that time says specific performance we can deal with later. And so then it goes to the jury. And at that point, I mean, it's clear at that point that the parties are still, specific performance is still on the table. And the court's just going to deal with it after the jury awards finds the amount of damages.
Are you saying, again, focusing on the fact that it's an equitable remedy, a court could never, forget about what Judge Crandall said and did in this case, a court could never exercise its equitable judgment after a jury verdict and say there has been a waiver or an election?
I don't think it can say there's been a waiver or an election at that point. I think it could put it to the party and say, you have your damages verdict. Do you want to, proceed forward with specific performance, and then I'll litigate the entitlement to that specific performance. But I don't think it can say simply by litigating damages that you've waived your right to specific performance, especially when the parties along the way had said specific performance is still on the table, Your Honor, and the judge says, well, we'll deal with that afterward. I mean, that would sort of be the judge luring the party into making an election of remedies before the time even for election of remedies is at hand. The Air Combat was entitled to know whether it had a right to that remedy before it elected. And by the way, in terms of the equities here, the real estate analytics case notes that there's never been any case in California where a trial court's finding that a damages judgment was sufficient is enough to rebut the presumption of inadequate damages in a context where there's a transfer of an interest in land. In other words, there's never been a court of appeal that would affirm a trial court's finding that a damages remedy was adequate, right? There's not one. And I don't think this court should be the first. And I don't actually think that's what Judge Crandall said. What Judge Crandall made the mistake of doing was saying that there was going to be a double recovery somehow. That's explicitly what his order says. And that's just not true.
Doesn't that suggest he was concerned about an election of remedies? Doesn't that suggest he was thinking about, along the lines, election of remedies, you got to elect between damages and specific performance? There's a double recovery, in other words. Doesn't that suggest that thinking to you?
It may suggest that he was under the impression that Air Combat had elected at some point, but that's, as a matter of fact, not true. I mean, and again, I understand the transcripts were not in the record at the time, but we have we've moved to augment in response to the city's statement that Air Combat never made clear that it would give up its future damages. We put the transcript before the court in a motion to augment. And on the record, it's very clear. Air Combat's counsel says, Air Combat has given me permission to tell the court we'll give up the future damages in return for the property.
You're
Right.
at 30, you're at 38 minutes, just so
Okay.
you know. If you want to save two.
The final thing I will say in that regard, very briefly, is in response to the Hangar 21, the current tenant. And that is this: specific performance remedy does not mean exact or identical performance. The city can relocate Air Combat within the airport as space becomes available. They don't have to return to that very specific hangar. Cities never claim that there's no space available for Air Combat anywhere on their airport grounds. And so on that ground, we think the court should affirm the judgment, but reverse the denial of specific.
One last question before you sit down. I'm curious to know what your feeling is as to what the latest time that a party is required to elect remedies.
I think when the issue is, when the specific performance issue is being decided by the court, and the court.
So you don't have to decide it even before the court starts to adjudicate the specific performance issue.
Well, you're entitled to know whether you have a right to it before you have to elect between the remedies. And even if it were true, Your Honor, that you had to elect sort of before the court decided, in this case, although the briefing was not, I admit, totally clear, the city understood Air Combat in its response brief to the specific performance. The city says they're trying to throw the jury verdict out and try to get specific performance. So the jury understood the city understood that even before the hearing, that Air Combat was making an election of remedies and willing to forego the jury's damages in order to obtain specific performance. And then to the extent there was any ambiguity about that, that was made crystal clear at the hearing. And I think that is ample time. It's before entry of judgment. That's what the Ramsgate and the Rome case say, that the before entry of judgment, a party's entitled to elect its remedies. And I think Air Combat certainly did that here. Does that answer your question?
Yes, thank you.
Thank you, Your Honor.
I'm going to give you a bonus minute for your reply, Mr. Lundell, and I'm going to give Ms. G a bonus minute. In her 7 minutes, you got
Thank
you can talk about, basically you should be talking about, well, now you reserve some time, so you can talk about whatever you want.
Right. Well, I'll start with the specific performance issue just because, we've been on that for a few minutes. First of all, I'd just say that I think it was an afterthought, honestly, because there was some discussion. I think we referred to that in the briefs about the specific place where they were discussing the issues that were left. And I think it was perfectly reasonable to have had the court determine whether there was entitlement to specific performance, i.e. inadequate damages, before it went to the jury. They talked about the inverse condemnation. They talked about the contract interpretation. Those were matters for the court. Never did they really say when specific performance was going to be determined. And it wasn't even brought up at the end of trial. So the verdict, even when the verdict gets issued, no discussion about, oh wait, there's one more issue, specific performance. It's brought up completely as an afterthought.
Several times during trial, though, they did sort of kick the can down the road, right?
Right. But I think that it needs to, and based on the case law that we had relied on, I think it needs to be decided sooner. And it isn't the kind of thing where it's supposed to be allowed for a party to wait and essentially here decide the damages weren't good enough. And
There are several cases, as cited by Mr. Lundell, that talk specifically about prejudgment.
Right, except some of those were talking about rescission and other kinds of remedies other than specific performance. So whether or not that translates to specific performance, I think that we had asserted that it didn't. But the bigger problem is that they have the opportunity then to wait and see if the damages are not good enough. And that's essentially what they argued. Also, I will note that the city did not have the opportunity to respond to the transcript because it was not available at the time of our briefing. Also in terms of the argument about there being other space, there's no facts that there's any space available whether it's that space or some other space at the airport. So it just is not an equitable remedy when it could require the vacating of some current tenants.
Ms. G, what's the reality, if we ordered specific performance, what's the reality of the impact of such an order?
Likely a tenant would need to be vacated illegally. And the other problem that raises is that tenant would have a specific performance claim. And whose specific performance claim would be superior? And it creates a conundrum, and it causes the court to require equitable relief that it does not affect justice. So I think under the circumstances, and I think that this court can interpret Air Combat's behavior as being a waiver. So even if the trial court didn't specifically state that, even if the trial court relied purportedly on double recovery, and I think that's still a problem because I think they came into it, whether the city understood it as something else or not, it seems clear that the court interpreted Air Combat's position as being getting double recovery.
And what specifically constitutes the waiver in your mind?
I think it's the behavior relating to the specific performance. So I think it's the fact that the issue was discussed, but there was no bringing it up. There's no request for the court to determine that prior to jury. There's no request for the court to determine that even right after the jury verdict. It wasn't brought up until much later when there was a proposed judgment, and the record isn't even clear how that was brought up. Obviously, the trial court allowed it to be briefed, but it was basically brought up with a proposed judgment that's not in the record. So I think it was a delay. And then I'd like to go back to a couple key points on the contract interpretation. I had addressed this briefly, but the court's reference to sharply divergent versions, it does not make it a factual dispute. That is just different inferences from primarily undisputed facts. So the majority of the facts are not disputed. And in terms of the drafting, I addressed that briefly. The court basically relied on the fact that it was on city paper and signed by the city manager, which it doesn't establish that the city drafted it for purposes of contract analysis. And that's the very last tool that the court is to use, only when all the other tools fail. So we have so many other tools to get to in terms of contract interpretation before we ever get to who was the drafter.
Ms. G, in terms of what the trier of facts responsibility is, though, doesn't a jury or a court in a court trial, a judge, determine what the facts are and what the reasonable inferences to be drawn from those facts are? Isn't that exactly, we instruct jurors about that all the time. That's what your function as a trier of fact is. Figure out what the facts are and then draw reasonable inferences. That's not a legal issue, that's a factual determination.
Right, but this is all about contract interpretation and which pieces of evidence, extrinsic evidence, need to come in.
Well, there's lots of evidence about this contract, though. I don't think you can say this. Our dilemma here is to look at the four corners of the contract and decide what the language means, although that's a big part of it. But there's a lot of other evidence that we have to consider here that I brought up earlier. For example, the airport manager making all those statements, the city attorney rendering opinions. There's a lot of other evidence other than the four corners.
Right, but I think when the court starts with the contract itself language and starts going through the conduct of the parties, how they acted, all of those things come up before there was ever a dispute. So, and the October 1st date is problematic because it makes sense when you use the date on the agreement, which is June 1st. And counsel argued that as of the date, June 1st, OCFA was the current tenant. That is not the case. June 1st is just the date someone typed on the agreement. It wasn't even signed that date. We know for a fact it was recorded the day before. We have no idea in the record or between any of the parties when this agreement was signed. So it happened at some point in time before that, whether OCFA it could have been before OCFA had moved out. So
They never really moved out, though, completely.
Well, I mean,
helicopter was
by
there.
the court's interpretation, they still haven't moved out because the blue cage is still there.
Oh, no, they abandoned it.
Well, but that's another point that counsel had raised. There's nothing indicating that they abandoned it. There's nothing indicating that at the time that they came and picked up the helicopter, they weren't going to come back the next week and get the blue cage, or that they weren't going to come back another month from then. There's
Except that
no.
They never did.
Well, now we can say that in hindsight, but that's not, I mean, what we're supposed to be looking at for purposes of the contract is what happened then and what did the parties
Exactly
understand
what
then.
happened then. It didn't happen then.
Well, but there was nothing indicating that they abandoned it.
Other than they never came and got it.
But again, that's only applying hindsight. I mean, we can only know that today. We don't know that as of
Every day that they didn't come back and get it,
Well, the
It was
point
there.
is that it makes no logical sense for the court to say that the helicopter is the date that they vacated because there was an equally similar piece of equipment that they didn't pick up at that time.
how does that help you to make it earlier?
Well, because it first of all, it eliminates that. It means that the helicopter can't be the date to vacate either. And it just comes back to the original point that I was making about the court just unreasonably looking at what does it mean to vacate? It means that you leave and the other tenant can come in. That's what it means. And the other problem with the October date is that that was based on someone looking at the date of the agreement, which is dated June 1st. It's the date that was sort of selected, most likely because that was when they wanted to trigger the 3 months had occurred, and so they recorded it and put that date on it. So when the assistant created the cheat sheet and looked at the June and then July or the June 1st and then gets to the October July, August, September, and then October 1st is the date. That's completely inconsistent with what the court did. The court said, well, it's July 1st, but I'm still going to come up with October 1st.
Okay, you're well beyond your 8 minutes. You need to wrap it up, please.
I think I've covered all the only other thing I wanted to say was on the claim issue. I think that the facts are more similar to Donahan and Fall River, where there's a divergence of the facts. There's just the claim to that there was a timely renewal. That doesn't give any facts or circumstances that give any indication of what Air Combat actually ended up basing their entire case on, which was the misrepresentations. That's not reasonably within that. That was the only other point that I wanted to make, unless there's any other questions.
Thank you, counsel. Mr.
Thank
Lundell, you have the last 2 minutes.
So I just want to address the specific performance issue, I think, Your Honor, and that is, again, they claim that they're going to have to remove some other party from the airport, and I just think that there's no evidence of that. They never asserted that below. The only thing they asserted was that Hangar 21 was in the space that Air Combat occupied before. So no evidence that they're going to actually have to evict everyone. Tenants come and go from the Fullerton Airport just like everyone else. There will be space there available for Air Combat. This is unique to Air Combat's business.
Is there any evidence in the record of what you just said either?
That it's unique to Air Combat's
Yeah,
business.
there's rotation or
I guess there's
turnover.
not, Your Honor. I guess
Just wanna make sure.
fair enough. But this is unique to Air Combat's business. It's close to Los Angeles tourism. It's close to the open spaces where Air Combat can fly its aerial maneuvers. The short runway means that only smaller planes have access there, so the rent's cheaper. This is absolutely critical to the existence of Air Combat. It's not an exaggeration to say that Air Combat cannot operate out of another airport. And if it's allowed to stand, that they're allowed to kick him off inappropriately, in breach of the lease, remove Air Combat. It's not an exaggeration to say that the city's breach of the lease will have destroyed a 30-year-old family business. Air Combat will have to close its door.
Ever investigate any other airports?
There's
Florida,
evidence
Santa Monica.
There's evidence in the record that they investigated lots of different airports, and none of them can satisfy the requirements that the Fullerton Airport does. And this is post-record, so the court can't really consider it, but it's since then has explored lots of options to try and stay in business. And the leases are outrageously expensive because these big airports want big jets, right? So it's going to have to close its doors. And the city's breach of the lease, a lease that his father had negotiated specifically to be able to operate at Fullerton Airport for the foreseeable decades in the future. The breach of that lease will have driven a valuable business, a 30-year-old family business, to close its doors. And with that, I'll rest, Your Honor.
Thank you, counsel. Well argued by both sides. Matter submitted.
Agreed.
We're in recess until this afternoon.